Hello and welcome to our 11th webinar in a series which we started back in May. In today's session, our speakers are discussing fire safety in tall buildings, the legal and technical issues, clearly a very timely issue as just a few days ago, the draft Building Safety Bill was just published on the 20th of July. I am Stacey Sinclair, the Head of Technology and Innovation here at Fenwick Elliott, and I'm joined by Jon Miller, a partner here at Fenwick Elliott, who specializes in construction law, advising on construction contracts, appointments, all forms of dispute resolution. Jon's also an experienced mediator, adjudicator, and arbitrator. We also have with us today Glenn Horton, director and founder of H&H Fire, who, as well as acting as an expert witness on claims involving fire and, of course, cladding issues, was a part of a panel comprised of the RSCS, the Ministry of Housing, Communities and Local Government, UK Finance and others, that drafted the EWS1 form, which we no doubt will be hearing and discussing in due course. That's the form intended for recording what assessment has been carried out on the external wall construction of a residential building. Glenn is also involved in with a number of others in looking at the introduction of the Hackett Inquiry recommendations, and he regularly discusses issues facing the insurance and fire consultancy industry. So before I pass over to our speakers, just a few administrative issues. Not to worry, everyone's on mute, and hopefully by now you will have seen the questions box in the right-hand side of your screen. If not, do press the red arrow, and that should pop out. Please do submit questions as we go. We will take as many of your questions at the end as we can. And rest assured that the questions will be put to our speakers anonymously, so please don't hold back. And finally, the slides and the recording will be provided on our website on demand very shortly after the webinar to be available for you. So without further delay, Jon, I shall hand over to you.
Thank you, Stacey. As Stacey explained there, I'm going to describe where we are at the moment with certain court cases in relation to cladding and the fire envelope, whereas Glenn will be looking forward to see what's happening in the future. My main role is to explain there have been 2 or 3 reported cases of the court involved with cladding and the building envelope. And what's surprising is that we're all aware, and not just those who have read the Hackett review, the problems that the construction industry has had with the building envelope, cladding, fire barriers, but all 3 or 4 cases have failed. No one has managed to obtain compensation. I'll explain the whys and the wherefores. Also look at COVID, what it means for building inspections and what have you. And then finally, just look at where we as a firm are seeing cladding cases, cladding disputes are going at the moment. Now, the first of these cases is the first port property case. Now, this is the first reported case post Grenfell that dealt with the building envelope. Here we had 95 apartments in a block where allegedly there was defective cladding that was dangerous. The usual, if I can say that, defects were uncovered. The tenants, the owners of the apartments, were faced with a service charge of £2.4 million. That covered the replacement cost of the cladding and also a waking watch. They challenged the service charge on the basis of the service charge primarily was for painting, decorating, wear and tear, and possibly even replacing the cladding at the end of its life. They said the service charge was not to cover defects in the original design and construction of the apartment block, and this went to the leasehold tribunal. The tribunal found that the leaseholders had to pay the service charge. It all turned on the terms of the lease, and we'll see this as a reoccurring theme. The lease was for 995 years. The freeholder stroke the landowner had very little interest in the property. He had basically devolved, given away most of his rights you would normally expect as the landlord, and there was a management company involved. So in those circumstances, it was found that the building manager had to replace the cladding, and it was not the landlord but it was the apartment owners that had to pay. Just a couple of points there. I'm told, and be a little bit careful, this is just what I've read in the papers, that eventually the apartment owners did not pay. There was some sort of arrangement thereafter with the people involved with this building. And also, claims against the people who were originally involved with the construction and the design of the apartment block did not proceed, primarily because they were outside the limitation period. They were too late to bring, hence the claim was brought pursuant to challenging the service charge under the lease. Now, this sort of identifies a problem that is another reoccurring theme in that, unsurprisingly, legally speaking, it's easier to seek compensation if you have a contract with the wrongdoer, with the contractor, the designer, the engineer. Okay. If not, you have to rely on negligence or possibly the Defective Premises Act. And the Defective Premises Act covers works that are done to a dwelling. A duty is owed to every person who acquires an interest in the dwelling. The duty is owed not just to the person that you're in contract with, so a duty is owed to everybody who has, say, a leasehold interest in an apartment block. The duty is to ensure that the work is done in a professional or workmanlike manner, whereby the dwelling is fit for habitation at completion. It is not dependent upon any contract. This is what happened in our next case. The lessees or the Heron Court case concerned an apartment block where numerous parties were defendants. The management company, the original builder, but significantly, the approved inspector was also party to the litigation. And there, the claim was based upon the Defective Premises Act. The remedial costs of the building envelope were £3 million. And, put it simply, the lessees and the management company said the building inspector owed them a duty under the Defective Premises Act as they were a person taking on work, and therefore the duty was owed. Now, possibly quite surprisingly, the court found that an approved inspector was not caught by the Defective Premises Act. Now, to quote the Court of Appeal, what they actually said was that a building inspector did not make a positive contribution to the design or construction of the building. And they approved the original comment made in the High Court in the Technology and Construction Court that a building inspector's essential function is not to contribute to in any meaningful way to the design or construction of the building, but rather to certify simply whether or not that design or construction is lawful in the building sense. So that claim based on the Defective Premises Act against the approved inspector failed. The next case, I feel a bit of a sort of fraud mentioning it, and I'll explain why at the end of this, is the Wharfside Generation case. Here, a typical scenario, a cladding panel blew off the building in 2009, and it was thought that there were problems with fixings. When it was investigated, what they found were missing fire barriers and other problems that we're coming across daily in relation to the building envelope. Now, it was accepted without any admission of liability whatsoever that if the cladding, which was Stowe Classic, contravened the building regulations, even then it should be taken down and disregarded, and it should be a complete replacement by Stowe Vario. Now, I stress this was without any concession to liability, so the decision as to whether the cladding was or was not in accordance with the building regulations was not made. The parties had agreed on a remedial scheme in case the court found one way or the other. Now, the point being now that the replacement of the cladding was said to have cost £3 million, and the agreement was made formally on that basis. What happened then is 6 months further into the litigation, there was a revised estimate and it trebled. The cost of replacement was then £9 million. And the defendants went back to the court and wanted to withdraw their admission that replacement was necessary, and wanted to, again, the court to consider again whether a repair of whereby the cladding was replaced and then put back again was sufficient or not. I stress again, there was no admission as to liability. This was purely about the remedial scheme. Now, normally it can be difficult withdrawing admissions when you're in litigation in the court. Here, however, the judge allowed the defendants to withdraw that admission and argue again or put points forward as to whether a complete replacement was necessary or if a repair was a more viable option. The court found there that there's no reason why the defendant should be prejudiced because the cost of the remedial scheme had gone from 3 million when the admission was made and was now 9 million. The reason why I feel a bit of fraud mention that case, as far as I'm aware, that case never reached a judgment. I don't know if it was settled or I doubt it's still ongoing with the court. The court allowed the issue of repair and replacement costs to be considered, but there's no final judgment on that point. The next case raises several issues, and it's the Sports City case. Now, here we have 350 apartments over 5 different blocks. There are arguments even as to when completion had taken place. There was a dispute whether completion of the blocks had taken place in 2007 or 2010, 3 years apart. Now, it raised a number of issues in relation to what were described in the law report as life-threatening defects in the design and/or construction of the cavity barriers and fire-stopping measures. Now, Countryside were parties to the lease, and one of the issues were, under the terms of the lease, and we looked at the lease earlier, were Countryside responsible for the repairs to the fire barriers, etc. The defendants also relied upon the Defective Premises Act, and there was a further alternative argument. The defendants alleged negligence and founded their action in negligence, saying reasonable skill and care had not been used in the construction, design, etc. of the building, and therefore they're entitled to compensation. Now, the leases here on this particular building or development were quite complicated. Not only were the apartment owners party to the lease, also the management company, the landlord, and Countryside. Countryside were not described as the landlord. They were developing the whole area, and the point about this, the landlord and Countryside had a separate development agreement that they were party to. Now, the tenants relied on a covenant from the landlord, whereby it was said to ensure that the blocks would be completed in accordance with the plan and specifications approved by the local planning authority. And they also relied on the usual covenant of quiet enjoyment. They should be allowed to use their apartments for the purposes that you would normally expect. Now, although Countryside were not described as the landlord, there were again some unique features of these leases. First off, when you bought an apartment, you paid Countryside. You didn't pay the landlord, the freeholder. Okay? That was covered by the development agreement. There were numerous rights which you would normally expect the landlord to hold or to have or reserve them to him, but they weren't. Countryside were the owners of these rights. Countryside approved the leases. So the tenants alleged, their argument was that Countryside really were the landlords and the obligations were owed by Countryside. Okay, getting back to this point, it's what is said in the lease. The court held that Countryside were not the landlords, particularly as, if you look at the document as a whole and the land registry, they were not described as the landlords. So the Countryside did not owe these obligations. Now, the tenants also relied on the Defective Premises Act, described before about ensuring that a dwelling is fit for human habitation. Now, the point there is the Defective Premises Act has a limitation period. In essence, you have to bring an action within 6 years of completion. As I mentioned, there was a dispute about when the blocks were actually complete. Was it 2007 or was it 2010? To some extent, it didn't matter. The court took the later date, 2010, added 6 years and said, you're too late. However, that wasn't the end of the story. The tenants also relied on some remedial works that were done in 2014 and an inspection done in 2017. and alleged the 6-year period should start from either 2014 or 2017, and therefore they weren't too late and they could rely on the Defective Premises Act. Interestingly enough, so people are aware of this, under the Defective Premises Act, you have an obligation to ensure that your work is done in a professional or workmanlike manner. That covers omissions. That would cover a survey if you've looked at a building and said it is perfectly fine and it turns out it isn't. But the court found that in this particular occasion, you still counted 6 years from 2010. One of the problems that the tenants had is that they couldn't clearly identify the remedial work that took place in 2014 or the report in 2017, exactly what it covered and what it didn't cover. The court said you could still bring an action for the remedial works in 2014 or for the 2017 report. They were within time, but that wouldn't be used as a reason to extend the limitation date for the original works that were completed as late as 2010 and whereby the limitation period had expired by 2016. They also brought a claim in tort for negligence, and that was dismissed in one paragraph. The basic rule there is that if you are suing someone in negligence, save for negligent misstatement, you cannot recover the cost of repair to the article itself. It's known as economic loss. That's why people have contracts, people have collateral warranties to avoid this argument. So the court simply dismissed that claim, saying it was economic loss, and therefore whoever was negligent, they were not negligent in the sense that you could recover the loss of repairs to the building. They are the cases that have come before the courts dealing with cladding in the building envelope. What I also need to look at is where we are at the moment in relation to COVID-19. The bottom line is that COVID-19 should have no effect on remedial works when it comes to removing cladding, dealing with the building envelope whatsoever. The government has made it clear, and it's in a letter signed by the Secretary of State for Housing, Communities and Local Government, that replacement of cladding work was critical to public safety. So in theory, at least, throughout the whole of the lockdown, remedial work should have continued. There's no reason why it shouldn't. The government have also made it clear that building inspections, assessments should continue as well. There's no reason why they should not happen. The suggestion from the government is that there should be remote inspections, possibly the use of video, and inspectors should carry on in their duties. Some people have even suggested drones should be used to inspect. I struggle with some of that. The other thing I struggle with, it'd be interesting what Glenn's got to say about that, in the sense of there was criticism of people marking their own homework pre-Hackett. And if you are going to rely on a video, who has actually taken the video? How is that going to work in practice? Now, I'm not au fait with every building inspection, but I've not heard of one inspection during the COVID period that has taken place using a video. Now, just drawing this all together in conclusion, what we've done there is to show, first of all, in that virtually every attempt at litigation in court to seek compensation for defects in cladding post-Grenfell have failed. They've largely failed because parties are not in direct contract with the original builder, the designer, or the person they allege that did wrong. They've had to rely upon the Defective Premises Act, negligence, tort, and what have you, which can be difficult. Not impossible, but it can be difficult. That's not what we are finding, just to step back from there. We are finding that contractors, architects, designers are getting involved in disputes, and so are their insurers, where there was insurance, in the sense of there are a large number of adjudications we've been involved in, but an adjudication is a dispute resolution process between the two people who are party to the contract, let's say the original builder and the tenant. If you don't have an assignment of the contract, a collateral warranty, a building contract, it can be difficult. Where litigation often comes about also is adjudication can be its biggest strength, can be its biggest weakness. It's only the two parties to the contract that are parties to that process, or indeed party to an arbitration. if you're an employer, you're not sure whether the problem with the cladding was either the builder's fault, the designer's fault, the architect's fault, the clerk of works fault, you normally need to litigate so that you can join all those parties in one piece of litigation. Otherwise, with adjudication, you have to go separately against, say, the builder, and then if not, the architect, then the clerk of works, or whatever the case may be. Turning to the other point that I raised there is no reason why approved inspectors should be not carried out inspections throughout the COVID shutdown and throughout sites that are working in accordance with SOP version 5, I think it is at the moment. Building inspections should continue, and the government's been very clear that they should, as should the remedial works as well. I've deliberately just looked at where we are at the moment and tried not to look forward, but there's just one point I have to raise, which is in all of 8 days' time, the deadline for registration for the government scheme for replacement of non-ACM cladding will shut down. You have to register. There's a £1 billion fund for landlords and other people alike to seek compensation where they have to replace non-ACM materials. That is in addition to the £600 million scheme, I think it's 600 million, that's in place now for replacement of ACM. Okay, that's a brief description of where we are at the moment in relation to tall buildings and the building envelope. Glenn will take you forward as to what's happening now.
Thank you very much, John. Hopefully everybody can hear me. With regards to COVID-19 and inspections, site inspections and visits, it's not something I plan to go into detail on, but more than happy to take questions because it is an issue that has affected us as a business and our clients. So in this presentation this morning, I'm just going to touch on the new fire safety bill, the building safety bill, EWS1 forms, and some issues that affect the industry generally, but obviously specifically related to fire engineers and fire consultancy, and some of the issues that impact on us going forwards. And at the end of the presentation, I'm more than happy to take any questions on about anything I say or anything you think might be relevant, I guess. So the fire safety bill is being brought forward, and it will amend the regulatory reform fire safety order. When a building is occupied, the regulatory reform fire safety order requires the responsible person, which is typically the building owner or manager, to carry out a fire risk assessment. Historically, those fire risk assessments have been carried out in the form of looking at the internal portions of the building, the common corridors, the staircases, and ancillary accommodation. And bizarrely, there's a school of thought that suggests that historically nobody needed to look at the envelope of the building. As an individual, as an engineer, I find that astonishing that we could look at a building that had combustible cladding, and if we take an extreme example, let's suggest it's thatch, just for want of an argument, that somebody carrying out a risk assessment would not look at that as they approached the building and said, I'm not interested in that. Apparently the government and various other bodies thought that from a legal perspective that was the case, and so the fire safety bill will address that situation and will specifically mean that the external envelope of the building will definitely be part of any fire risk assessment going forward, as will balconies, which again many people are arguing or trying to argue that they weren't covered in the risk assessment, nor are they covered in building regulations. Again, my view is that that's a very narrow and naive view, but then I'm not a lawyer, which is why John's organisation will advise on those kind of issues. So in the fire safety bill, these items will be specifically mentioned as part of the risk assessment, or should be. Also, entrance doors to flats. The entrance doors to flats are another really significant part of any fire safety strategy for a residential building. And there's been a long dispute about whether they form part of the common parts of the building or whether they're actually part of the apartment owner leaseholders' demise. And so that's being clarified in the new regulations. And the fire safety bill will introduce secondary legislation to take forward the Grenfell Tower Inquiry Phase 1 recommendations. In summary, the fire safety bill, therefore, will increase or confirm, rather, perhaps what should have been evident and clear to risk assessors for the risk assessment of residential buildings going forward specifically. So that's in summary the fire safety bill. Post Grenfell Tower, a number of other actions that the government have brought forward, and in particular, there's been a lot of discussions about a building safety regulator and the need for all buildings to have a safety case, all buildings that are relevant, that is, which is typically residential buildings over 18 metres. There's an introduction for the building safety bill. We've just seen the draft published on Monday, and I've got a few points to raise about that. But the purpose of that bill was to make clearer the accountability and stronger duties on those responsible for high-rise buildings. And as you can gather from Jon's presentation, there's a lot of dispute, both in a legal sense and in a practical sense, about who has responsibility for what. Perhaps not a dispute in a legal sense, but in a practical sense, trying to work out who deals with which portion of the building and who should be doing which bit of work. A 1.6 billion fund to tackle unsafe cladding systems on the high-rise buildings has been announced. Initially, I think it was 200 million. Then it was increased to 600 million, and now it's been further announced that there'll be £1 billion to assist building owners with the remediation of buildings with unsafe cladding. This might seem like a really simple and straightforward approach, but for those of you that are involved in such schemes, in the investigation of such schemes, it rarely is a simple and straightforward approach about whether a building is or isn't unsafe, despite what may seem evident. Simply having combustible materials on the outside of a building is not of itself absolute proof that something is non-compliant, unless of course it's a building built post December 2019 when the building regulations changed. But prior to that, it's certainly not clear in many cases. And then whether this is a minor add-on thought or not, I'm not too sure, but the relaunch of the government's Fire Kills campaign, which is obviously a campaign to raise the awareness of homeowners and occupiers on the need for fire safety in the home. So the draft bill was published on Monday, and I've got a few quick snippets from it. You will forgive me not having read all 344 pages and digested and summarised those for you, hopefully. But these are some of the key points that have come out of the draft bill. So picking up on the point that I made in the previous slide about a building safety regulator, with the purpose to introduce better safety systems for the design and construction and management of buildings and to carry out enforcement. To my knowledge, there have been no enforcement actions under building regulations in relation to fire safety ever. I may be incorrect on that, but I've raised this a number of times in a number of forums, and nobody so far has corrected me. So I think I'm probably pretty close to the truth there. And the building safety regulator will perhaps change that perspective and make enforcement much more viable and I was going to say a regular activity. Perhaps regular is not the right word, but a routine activity where it's required. Currently, there's confusion in many projects that I work on and exactly who it is that has responsibilities for the various different stages of the buildings in terms of the individual is not particularly identified. Quite often it's simply an individual post rather than an individual as a person. And the introduction of duty holders at every stage of the building and various different gateways, for example, building control submissions, appointment of a contractor, will actually legally require individual duty holders to be named and identified, thus making enforcement more effective and I guess easier in the sense of identifying if anybody is alleged to be at fault, who that person is. Building safety managers will be appointed, and at the moment there is no formal obligation to have a specific manager the regulatory reform fire safety order does impose conditions where people have to carry out risk assessments and appoint people to carry out various functions, but it's not in the same format as envisaged in the Building Safety Bill. Increased sanctions, so unlimited fines and up to 2 years in jail, which would seem fairly serious. I guess it depends on your perspective, but certainly having these enshrined in the latest regulations would seem to be a sensible option. Having read through the summary about costs to leaseholders, I'm not too sure whether I've understood this correctly, but it seems that this really sets out that leaseholders will still be liable for those costs, going back to Jon's comments about potential claims. At the moment, many people feel that they shouldn't be liable for such costs, particularly where there's perceived to be some negligence on third parties. But certainly the cost to leaseholders for the fire safety and the fire safety improvements is going to be managed through this safety charge, which leaseholders will be duty bound to pay. No doubt that's going to thrash itself out when the bill becomes law. Cost to leaseholders of managed through building safety charge, which we've just covered. There's a number of new committees established or proposed to be established under the safety bill, and that's a Building Regulations Advisory Committee, which sounds very similar to the current BRAC, which gives technical advice to the regulators. One of the issues and one of the concerns about fire safety generally is the competency of the individuals carrying out that work, and that's certainly a concern shared by industry bodies, professional bodies as well, and they've set up a number of registers, but the new committee will look at that formally in terms of the building safety bill. And then there's a panel to take into account residents' concerns and a direct mechanism for liaison and involvement with residents between the Building Safety Committee and the residents generally. And then there'll be a new Homes Ombudsman who is envisaged to have some enforcement activities and will be able to deal with claims and concerns from homeowners directly rather than having to engage lawyers. So that seems to me to be in line with other areas of industry where individuals can go straight to an ombudsman. Just really to talk about EWS1 forms, because this is an issue that's formed a large part of my inbox over the past few months, and I know many others are involved in this, both in a legal sense and in a practical sense. The EWS1 form arose out of concerns which started to become expressed on a large scale, I would say about a year ago, 9 months to a year ago, by lenders becoming concerned over the quality of buildings and the status of cladding, and whether leaseholders and apartment owners would be required to fund any remediation costs. And the reality for many leaseholders is that if they were asked to pay a small charge, I'll say small in context of remediation of a building, of a few £1,000s, it might be an inconvenience to many of them, but it's unlikely to be unresolvable. Whereas the remediation costs for cladding can be significant. And you've heard in Jon's presentation about one claim which started off as 3 million and then escalated to circa 9 million. Well, if there's 100 apartments, that's a range of costs from 30 to 90k per leaseholder potentially. And it's quite clear to lenders that if faced with such costs, that leaseholders would find themselves in extreme financial difficulty, and potentially if they were legally obliged to pay such fees, then they would be bankrupt in many cases. And quite clearly as a lender, responsible lenders are not going to lend money where there's a situation that may give rise to their mortgagees being forced into bankruptcy through no fault of their own, and arguably no fault of the lenders. So towards the end of last year, the Royal Institute of Chartered Surveyors set up an industry initiative which involved the Ministry of Housing, Communities and Local Government, UK Finance, all of the major mortgage lenders that you will no doubt be aware of, a number of developers, fire engineers, landlords representatives, Uncle Tom Cobley and all. And we spent the best part of 3 months discussing how to resolve the issues. And the output of that was essentially the EWS1 form, which is a reporting mechanism. It isn't the assessment itself, and it isn't a safety certificate, although I'll talk about that issue in a minute. But in essence, it's a mechanism of reporting in a standardised way to lenders or their surveyors, ultimately, about the status of the building. And essentially, there's 2 options within that form. There's a section which is often referred to as Section A, which deals with essentially non-combustible cladding. And if a building has non-combustible cladding, then the theory is that a suitably experienced and qualified individual, perhaps a surveyor, might be able to identify those materials and confirm that by completing the form and doing their own inspections and investigations, that that is the case for a building, and that there is no reason why that cladding would need remediation, and therefore lenders may reasonably lend on that building. The second section, referred to as Section B, has 2 options. The first option is one that I'm most often asked to complete, which is when I carry out an assessment that the building may have some combustible materials in the external envelope, but on balance, I don't believe the cost of that remediation is likely to be prohibitive, or that the overall cladding of the building is likely to require remediation on a safety basis, and therefore it's safe for the lender to lend on it. This is related to cost in many senses, but of course it's related to safety as well. It's worth mentioning that all of the reputable fire consultants that I know that are being asked to complete these forms are taking a wider pragmatic view and not just simply saying it's non-combustible, therefore it's okay, or it is combustible and therefore it isn't. They're looking at the wider safety of the building and its occupants, and taking a view that if they don't think the building's safe, then they won't issue what might be described as a supportive or positive EWS1 form. The reason I put building safety certificate in question marks is because you'll gather from my previous comments that what engineers such as myself are doing is taking a holistic view about whether this form can be completed in a positive sense, and some are taking that to mean that it can be used as a safety certificate. I think that is perhaps stretching the point of the form too far, since the extent of investigations required to complete one of these may well vary from circumstance to circumstance, and it certainly isn't the intention that the EWS1 form is used as a building safety certificate. Whether it becomes so in the future is another issue, of course. So talking about the future and the impact on existing buildings, it's probably worth saying that my involvement with Fenwick Elliott and a number of other clients revolves primarily around existing buildings, of which there is a lot. Latest estimates on buildings over 11 metres is there's something of the order of 100,000 buildings in the UK which fall into that category, which may or may not require some form of investigation. And the government have carried out a number of tests, both on ACM materials, which is aluminium composite materials, and non-ACM materials, and drawn some conclusions and published some guidance. And one of the ones that is causing particular interest at the moment is standard HPL panels combined with combusted insulation. HPL stands for high pressure laminate boards. And what that is a product which is compressed wood or paper fibres mixed with a resin and compressed to form flat sheets. Typically highly coloured, in some cases with different textures on the outside, but extremely popular on a range of buildings of all heights. And so it's difficult to draw estimates, but I would hazard a guess that there are many more buildings with this kind of product on it than there are with ACM on them. And you may well recall that there was a fire in Bolton, I think it was student accommodation, which involved such panels, and fire spread across the envelope of the building. The other issue which is causing concerns is buildings less than 18 metres. It's worth noting that the building regs has a number of requirements in there, and the one that deals primarily with the external envelope is requirement B4. And the actual regulation itself does not refer to height at all. It's a functional requirement, and therefore any building arguably should be considered in terms of whether the combustible envelope is an issue. And it's worth noting that as a business, we've been asked to look at a number of buildings which are much less than 18 metres. And in some cases, we've concluded that those buildings do require some intervention. I have to say that on balance, many buildings that we look at don't require intervention simply on the basis of the cladding, but it isn't a foregone conclusion. And therefore, it's possible that we would be asked to investigate such buildings. I've made the final point there that Building Regs Requirement 7.2, which was amended in December last year, does refer to relevant buildings over 18 metres, but historically it didn't. Sorry, historically Building Regs didn't. Just to put a scale of things, in terms of the problems that the industry faces, and that's me as an engineer and you as potential clients and solicitors, etc., there are about 50,000 chartered surveyors in the UK, plus other grades. The Institution of Fire Engineers, which is my professional body, has approximately 280 chartered fire engineers worldwide. So from that, you will gather that my inbox is pretty busy, and I'm turning down as much work, as probably much more work than I'm actually doing, simply because I don't have the availability, and nor does the industry generally have the capacity. Making the point about buildings and the work that might be required to be done, circa 10,000 buildings over 18 metres in height, which, when I say may require, lenders are insisting that buildings over 18, residential buildings over 18 metres have EWS1 forms. And there's about 100k over 11 metres, which many lenders are asking for EWS1 forms on. So I'll leave you to draw your own conclusions, but it is a significant issue for the industry, whichever part you're involved in. How does this impact on us? You won't be surprised to know that PI insurers are interested in these issues and the number of potential claims. It affects all sectors of the construction industry, and gaining PI cover for work involving tall buildings of any description, and all of the products that I've listed there are issues which face the industry and which claims are being brought that I'm aware of. There's potential criminal liabilities under the Regulatory Reform Fire Safety Order, and there's been lots of discussions about these issues fairly recently. I am aware that there are prosecutions have and continue to be brought under the Regulatory Reform Fire Safety Order for failure to identify risks appropriately. I suspect they will increase. And of course, with the increased enforcement activity, and when the Fire Safety Bill comes out and the Building Safety Bill is enacted, it's likely that these things will only increase. Thank you very much. Any questions?
Thank you, Glenn. Thank you, John. I can certainly say, Glenn, that if your inbox has been flowing over, the questions are as well coming in, and indeed, particularly in with respect to the EWS1 form. So perhaps maybe if we could dig a bit deeper into that, actually. Some are asking who was intended, perhaps actually maybe address this in part, who is intended to actually complete the EWS form?
I think this was always going to be a difficult issue, simply because, as you will know from my last couple of slides, that the number of people involved in the fire safety industry in the UK, and particularly chartered fire engineers, is extremely limited. And so the intention was to try and create, I'll call it a two-tier system for want of a better phrase, but certainly there will be many buildings that lenders are asking for EWS1 forms that have either non-combustible envelopes or have materials which have been tested. and there's test evidence available. And in general terms, the idea was that people who are not necessarily specialists in fire, but are surveyors of some stature, are there engineers who may not be chartered, but have experience of dealing with these issues, will be able to identify those materials and confirm that the evidence is available to suggest that those buildings won't require remediation. It's much more difficult because it's a much more complex task to review a building and say whether it does or doesn't comply with building regulations, and therefore whether it requires remediation, which is why there's a second option for chartered engineers. I have a view that there are many people who are not chartered engineers who may be technically competent to complete those forms in an assessment sense, but it is very difficult to identify who those individuals are. And so that is the challenge for us as an industry and for the people seeking completion of such forms. And I'm not too sure I have an easy answer, I'm afraid.
Are you seeing a reluctance with fire engineers or any professionals to sign these forms, therefore causing issue with the process?
The issue, one of the issues facing the industry generally, particularly fire consultants, is the small size of the market in insurance terms and the cost of that insurance to consultants. And on the flip side of that is the risks that insurers face in covering consultants. And so many consultants have restrictions on their PI insurance about whether they can or can't complete and under what circumstances they can complete these forms. I don't want to get into details about individual companies because obviously this is not the right forum to do that. But as a result of some of those concerns about insurance and liability, I am aware that some consultants will not complete forms at all. I'm aware that some will only complete them on projects which they've been involved in. And there are others like me who take a different approach and try and deal with those risks and liabilities in a different way. So there is a range of issues, but I mean, that's something else which is further impacting on the market.
Indeed. Someone has written in to say that I'm a building surveyor and our PII does not allow us to do EWS1. The form also specifically includes cavity barriers and insulation, not just the external wall material. Thank you for that. John, there have been a couple of questions, if I can go to you. In light of the cases you discussed, is there any scope for leaseholders to recover the very high costs they are now being charged to put right unsafe construction?
Yes, but provided they look to who they're in contract with, I mean, that's the easiest route unless they want a test case. I would expect leaseholders to have a collateral warranty from the builder, what have you. And they may also take an assignment, one of layman's term, a transfer of the building contract, the designer's appointment, from the landlord, from the developer, in return for making sure the developer is no longer involved. But the contractual route is the easier route. We all know that as lawyers, Stacey. So otherwise, you can see there's already been some novel arguments, which I highlighted in the previous talk. And it's difficult if you haven't got a contract. Me personally, I still think the Defective Premises Act has got some way to go yet when you get a claim from a leaseholder, and not against a building inspector though.
Thanks, John. Possibly Glenn, maybe you for this one. Is the Building Safety Bill or other legislation likely to pull in other building groups, not just flats, such as high-rise hotels?
I have to take the fifth on that. I don't know is the short answer. I mean, amendments to the fire safety order and risk assessment logically should include, I would suggest, all buildings, because whilst the focus is on residential buildings for obvious reasons, clearly if you have a hotel with people sleeping in the hotel who are unfamiliar with the building, it seems to me to be entirely logical from simply an engineering and a safety perspective that you would take into account the same factors You may apply a different weighting under different circumstances, the importance of those factors, but certainly as an engineer, I would consider that would be the right course of action. So I'd anticipate that the fire safety order will bring that into it. I haven't had time to go through the building safety bill in any great depth, unfortunately. So I'm not sure is the short answer to that at the moment.
No, thank you. Just maybe a couple more questions if I can, if the audience doesn't mind. We're still seeing a lot of EWS1 questions coming in. Someone understands that the EWS1 is currently under review, do you know anything about that, and possibly what changes might be, if you know anything about it, if there's any changes that are being considered to it? I
do know something about it, and you'll forgive me if I'm not going to go into details about what changes may or may not be forthcoming, because if it's under review, then you know what will happen. There is a forum. In fact, I've got a meeting on Friday to talk about guidance being issued in support of the EWS1 form. So I think that's probably something that's in the public domain already in terms of that's in progress. But at the moment, it's very early stages, and there's been a lot of discussions. There's been a lot of criticism about the EWS1 form, and I think there's been a lot of, perhaps a lack of clarity about what it's about, but it is a reporting mechanism, and on that basis, I think it does a job, but the reality is that it's a developing issue, which we're all continually looking at and moving forwards.
Great, thank you very much. And maybe, John, just one final question. What rights what rights of compensation does the client or owner have in case of a fire caused by building or material defects?
The simple answer is just they should have a right of claim against, particularly under contract with the builder or what have you. The actual answer, there's several cases pre-Grenfell, is that to show that that building defect caused or made the fire worse as a question of causation can be difficult. Missing fire barriers do not necessarily give rise to a fire, but they may make it worse. So this is one of the things that will come out of the litigation surrounding Grenfell that will eventually take place, but not now, whilst there's a public inquiry underway.
Thank you, John. I think, thank you very much to the audience for all of your questions coming in. We've run over, but I think it's been really useful to at least take on as many as we could. Glenn, John, thank you so much for the interesting debate that we've had. Thank you to the audience for joining us today. We've had such a successful turnout. And just a heads up for next week, next Thursday, same time, same place, we have our senior associates, Sana Mahmoud and Robbie McRae, speaking about ADR head-to-head, dispute boards and arbitration. So please do join us next week if you can. So thank you again for today, and take care.